All rise, veuillez vous lever. The International Residual Mechanism for Criminal Tribunals is now in session. L'audience du mécanisme international appelé à exercer la fonction résiduelle du tribunal pénal est ouverte. Please be seated.
Well, good afternoon to everyone in the courtroom or watching online. I'm conducting this hearing from the mechanism premises in The Hague, while judges El Baj and de Guzman are participating via video conference link. The hearing is being held within 120 days of the last hearing on the 6th of September, and pursuant to the trial chamber's order of the 8th of September that indefinitely stayed the proceedings. Counsel are in attendance, Mr. Elderkin for the prosecution and Maître Altit for the defence. However, Mr. Kabuga is not attending today's hearing either in person or remotely for medical reasons. We explored the possibility of postponing the hearing until tomorrow to increase the prospects of him being able to attend. However, the medical officer in the detention unit responded that waiting until tomorrow would be inadequate in view of Mr. Kabuga's current health situation. We therefore decided to proceed with the original plan to have the hearing today. Due to the importance of receiving updates on the efforts that are being made to secure Mr. Kabuga's provisional release, and in order to provide the parties with an opportunity to raise any other relevant matters, including about his health, welfare, and conditions of detention, the trial chamber considered it appropriate to proceed as I've indicated in his absence. In preparation for today's hearing, yesterday, the parties' counsel and I, along with representatives of the registry in attendance, had a case management meeting to focus today's discussion. Now, before hearing directly from the parties, I will give an update on procedural developments since our last status conference on the 6th of September. On the 8th of September, the trial chamber ordered the indefinite stay of the proceedings, given that Mr. Kabuga is unfit and unlikely to regain fitness for trial. This order brought to a conclusion the presentation of evidence and procedural litigation related to the trial to that point. In that order, the trial chamber also maintained a medical monitoring regime where the independent medical experts and the detention unit's medical officer will continue to report on Mr. Kabuga's health. The trial chamber also instructed the registrar to assist the defence with communicating with national authorities in any state where Mr. Kabuga seeks to be provisionally released. The trial chamber has also issued separate orders and decisions vacating a subpoena, altering the medical reporting regime by the detention unit's medical officer, and instructing the defence to file updates every 14 days on its efforts to secure Mr. Kabuga's provisional release. I turn now then to the question of provisional release. The defence has filed several updates on its efforts to secure Mr. Kabuga's provisional release. The trial chamber commends Maître Altit and his team on its diligence and tact in pursuing this difficult task. However, a solution has not yet been found. Now, Maître Altit, I turn attention to you first of all. Could you please provide your views to those listening today on the process, including your anticipated next steps? So where have you gone so far, and where do you anticipate turning attention to? It may be that this should be in private session. I'll be guided by you on that.
Merci, Monsieur le Président. Bonjour, Monsieur le Président, bonjour, Madame, bonjour, Monsieur. Monsieur le Président, tout d'abord, un mot d'ordre général sur le processus qui est en cours et que vous venez de rappeler. Nous faisons tout notre possible pour essayer de trouver une solution sous le contrôle de la Chambre, comme cela a été demandé par votre Chambre et par la Chambre d'appel. J'ai bon espoir que nous arrivions à un résultat, mais évidemment, ce n'est pas facile. Et maintenant, je vais vous demander l'autorisation de passer en audience privée.
I think in the circumstances that's an appropriate course to follow. We'll go into private session. And after a short period in private session, we'll be back in public view.
We are now in open session, Your Honour.
For those who were not able to hear what was being discussed in that period of time when we were in private session, I can at least tell you that the potential states to which Mr. Kabuga might seek to be provisionally released were discussed, and the efforts to persuade them and how they might be persuaded to take him were discussed, as was the question of whether formal proceedings should be initiated by the defence in relation to provisional release to one of these particular states. And over the course of the next week or two, I expect there to be at least one filing indicating the progress that's being made on that front. The next topic to which I wish to turn attention is the issue of the indigency of the accused, Mr. Kabuga. He has been supported in his defence of the case by legal aid on the basis of his claimed indigency. On the 6th of October, the registrar, having investigated that matter in detail over a lengthy period of time, issued his decision determining that Mr. Kabuga is not indigent and that he is capable of funding his entire defence. However, this determination is subject to the attribution of frozen funds and property to Mr. Kabuga, which he presently cannot access. The registrar has not requested the trial chamber to grant an order for contribution under Rule 43E for Mr. Kabuga to pay for his legal expenses. Instead, the registrar indicated in his decision that he will defer seeking such an order until the natural conclusion of the proceedings and/or a related order of the trial chamber, and that's where matters rest. The registrar's decision was public but contained confidential and ex parte annexes identifying, among other things, specific assets the registrar has attributed to Mr. Kabuga, which the prosecution has not seen details of. Whether these annexes should be shared with the prosecution was discussed at the meeting we had yesterday. I think I should take this in logical order, and that essentially means hearing, I think, first of all, from MICT-13-38, representing Mr. Kabuga and his interest in confidentiality. In the event, MICT-13-38, that the trial chamber considered it appropriate for the prosecution to have access to the details contained in the annexes to the registrar's decision, would you, on behalf of Mr. Kabuga, oppose that?
Pas d'objection, Monsieur le Président.
Thank you. Now, in light of that, the controlling hand in this is the registry. So can I have or hear now from a representative of the registrar indicating, in light of that concession, what is his position? Mr. Hicks.
Good afternoon, Judge Bonamy. Yes, Brent Hicks on behalf of the registrar. Good afternoon to everyone in the courtroom. In the absence of an objection from the defense, the registry takes no position on the release or rather the disclosure of these annexes, defers to the discretion of the trial chamber and will implement any related order. Thank you very much, Your Honor.
Thank you, Mr. Hicks. In view of the positions taken by, first of all, the defense and secondly, the registry, and also in light of what seems obvious to me, that the prosecution are likely to have access to means of advancing any claim that the registrar might wish to make to recover these expenses, it seems to me, on the face of it, appropriate that the defense, that the prosecution should have access to the detail. Now, Mr. Elderkin, is that something that you wish to have?
Your Honour, yes, we would generally appreciate that.
Okay. Well, in that case, I'm going to order that the ex parte status of annexes A to E of the registrar's decision of the 6th of October should be lifted vis-à-vis the prosecution. The annexes will remain confidential, but court management should now accordingly serve the annexes on the prosecution. Now, before departing from this topic, I would like to hear from the registry on the question whether it has any, or the registrar has any further submissions to make in relation to why he's not immediately seeking to recover the money already expended for Mr. Kabuga's defense. I would also like to hear whether a clear recovery plan exists. Now, if it's necessary for a frank exchange to take place on this, we'll go into private session if requested. If it can be conducted in public, then we'll remain in open session. Is that for you, Mr. Hicks?
Yes, Your Honor. I believe it is for me. And to the last point, I believe we can remain in public session in the sense that I can essentially reiterate that what is in the indigency decision, which is of course public, the registry doesn't have any further submissions beyond what is contained in that decision at this time in terms of recuperating the money that's been expended thus far for Mr. Kabuga's defense. As set out in the decision, and as you alluded to, the registry proposes to await a natural conclusion of the proceedings and or a related order of the trial chamber. This posture, as again stated in the decision, is to avoid disrupting the status quo as to the representation of Mr. Kabuga. Nonetheless, the registry, of course, defers to the discretion of the chamber and will implement any related orders that may be issued. As to a recovery plan, as alluded to in the indigency decision, and it's essentially a component of the anticipated order for contribution, in the sense that the registry would seek to have a discrete portion of funds released to reimburse what has been expended to date, and that is the conclusion of my submission on this point, Your Honor.
However, can I just be absolutely clear on this? Even though we have a figure for which you would say that Mr. Kabuga is already responsible, you don't seek at this point even a finding to the effect that that is the case, far less an order of the court that it should be reimbursed.
Respectfully, Your Honor, I would simply refer back to the decision. That's the position of the registrar at this time. There is certainly a figure in the decision, as you've alluded
Yes,
to.
indeed.
However, it's not a static figure. It's one that continues, obviously, to grow as time goes on. And so there, in theory, according to the decision, would be a final moment when legal aid stops and when there is a figure which would be definitive, let's say.
So I'm not pressing you for more details. I just want to be clear in my understanding of the situation. Beyond what's in the decision, there's no other factor that you want to disclose to us that is motivating what seems to me an unusual stance to take when everything is so clear-cut. There isn't anything else that we don't know about that's motivating this line that we'll leave it till the end of everything.
Respectfully, Your Honor, I can't say more than what is in the decision at this point.
Well, I can simply say that I'm puzzled by that. Money has a terrible habit of disappearing if you ignore it for long enough. And when you give or allow the opportunity for other claimants to come on the scene, I personally consider that the registrar would be well advised, and I am speaking for myself on this, would be well advised to consider whether it's wise to delay any further action in relation to this. But I'll leave that thought for you to relay it back to the registrar.
You could rest assured that I will, Your Honor. Thank you.
Thank you, Mr. Hicks. Now, Mr. Elderkin, do you want to say anything on the issue of indigency? Or
I have nothing to add. I obviously now look forward to seeing the content of those annexes, and I'll see whether then there's anything worthwhile from the prosecution side to input.
And Maître Altit, I assume that you've got nothing to add on this topic.
Monsieur le Président, en ce qui nous concerne, nous pensons que la position du greffe est très claire et nous attendons de voir la suite des événements.
Thank you. Now I turn to the normal subject matter of any status conference, and that's issues relating to the detention conditions of the accused and his health and welfare. And first of all, I would invite Maître Altit to make any observations he may wish to raise concerning Mr. Kabuga's health and the circumstances of his detention. Maître Altit.
Merci, Monsieur le Président. Monsieur le Président, pouvons-nous passer en session privée, s'il vous plaît?
Is that really necessary? There's no reason why details, well, if you're going to discuss details of health, yes is the answer. But can we not address this without the details of health problems?
Très bien, Monsieur le Président. Alors, je vais m'en tenir à...
If you're if you continue to be uncomfortable, raise it with me again.
Non, la seule chose, c'est qu'il est difficile de distinguer entre ce qui est assez général et les détails, naturellement. Mais je vais d'abord m'en tenir à des considérations un peu générales, et puis, si vous voulez, nous irons ensuite dans les détails, et ce sera certainement plus facile alors d'être en session privée. Pour ce qui concerne, disons, la situation générale, vous savez que sa santé est extrêmement fragile. Elle s'est aggravée récemment. Il a été traité, je crois, de très bonne manière. Il a été traité de manière efficace. Il n'en demeure pas moins qu'il est extrêmement affaibli. Nous sommes d'ailleurs très inquiets. Je dois vous le dire, nous sommes très inquiets. Nous sommes en contact constant avec sa famille, qui évidemment est très inquiète aussi. Mais nous pensons qu'il est bien traité, bien soigné, que tout est fait pour que les choses se passent bien. Et apparemment, les premiers résultats sont des résultats positifs. Donc voilà la situation. C'est une situation difficile, c'est une situation inquiétante, mais c'est une situation qui semble, pour l'instant, évidemment je parle sous le contrôle des médecins, mais qui semble à peu près maîtrisée. Peut-être pouvons-nous alors aller en audience privée, Monsieur le Président?
Just before doing that, the important thing from the perspective of the bench is that an issue like this, and it's physical health we're talking about here, not mental health, I think, at this particular juncture. That's the current problem. It's important not to miss the opportunity to discuss that openly. No decision will be taken that would in any way prejudice the interests of Mr. Kabuga today because of his absence. But we can make decisions that will be to his benefit today in spite of his absence. And if there is anything that you wish the court to do, then you should ask. And to hear you further on that, we will now go into private session.
We're back in open session, Your Honour.
For those who were unable to hear that last part of the procedure, the trial chamber were being updated on the particular physical problems that have beset Mr. Kabuga over the last few days and the progress he's making and arrangements that might be made in connection with his future care. But throughout it was made clear by Maître Altit that both the defence team and Mr. Kabuga's family are entirely satisfied with the arrangements that are being made at present for his care. Now, Mr. Elderkin, is there anything on this subject you wish to say?
No, Your Honour.
Thank you. Now that exhausts my agenda for this conference. First of all, Mr. Elderkin, is there any other item that you think ought to be addressed?
Your Honour, no, but since it was on the table for discussion yesterday, I would simply mention the housekeeping matter where we are preparing certain public versions of evidentiary materials, but that will be set out in a motion in due course. So there's nothing to be discussed today per se, just to record that that is in progress.
Well, I'm happy to note that, thank you. And Maître Altit, is there anything you wish to raise?
Non, merci, Monsieur le Président.
Well, I think that brings this status conference to an end. I thank the parties for their very helpful submissions and for the assistance provided in the course of yesterday's meeting and also in the course of today's hearing. I thank the registry and all the support staff in and around the courtroom for the efficient way in which this process has been set up and today has been conducted. The trial chamber as a whole wishes all who can hear us at this moment all the very best as we approach the end of this year and enter what I hope will be a happier and more peaceful new year. The trial chamber is now adjourned.
All rise, veuillez vous lever.